Hello, my name is Xue Yan. Now I will begin with the introduction. Australia contract law is based on the enforcement of legal promises, which are made regularly on a daily basis, from purchasing a coffee at the local coffee shop to executing an international trade deal bilaterally between two countries. This will form a legal binding relationship, and it is mentioned as a contract in the law. Common law exists in Australia and is based on and inherited from British contract law. The modifications of principles from contract-based case law in Australia courts has been derived from the British common law since the 1980s. The report reviews overall concepts of common law based on two case studies. In addition, it examines the differences between common and statute law. In order for contract to be established, there are essential elements necessary to create a contract, including offer and acceptance, consideration, agreements, certainty, intention, and capacity. Contracts can be terminated where there is a breach, frustration, repudiation, contentment, containment, conditions of failure, subsequent agreements, and the express right to terminate the contract. According to the law, not all promises are enforceable. Promises that are enforceable by law are relaxed from outdated common law. And this was determined in the Donald versus Stevenson case as complexes and that have not noticed in cause arose. In Australia, contract case law has been based on cases such as mentioned in the prior sentence. To extend, a promise refer an essential element that from a contract. Promises are enforceable in certain circumstances based on prior case decisions. Common law case law has been developed over history and enhanced to comply with modern world settings. Promises, small or large scale, will be considered with regards to their eligibility. As an example, misleading and deceptive conduct is litigable under the Australian consumer law. In Australia, the law is based on equity and precede contracts that have disclaimers with unfair limitations. Especially, there are elements that are necessary for legally binding contracts, which are capacity, consideration, time, intent, and agreement. The absence of any of these elements is signifying that, according to law, there is no agreement and the contract.
Hi, my name is Weng Meng Ng. I'm representing the case of contract law, which is Richards vs. Homebane, 1986. Richards used to stay in UK. His mother has promised him that she will buy a house and will put under his name. So, he has agreed to immigrate to Australia. Then his mother finally bought the house, but she titled under her name. After a certain period, Richards is moving out from the house because he was stressed due to the promise had reneged by his mother. Therefore, the son has brought in a legal action that the house should put under his name. The son has relied based on the existing of the contract from his mother. The mother has clearly promised to the son that to purchase property only on condition that he migrate from UK to Australia. However, the court has found out that there is no problem to set an intention because it is creating a legal relation the son has finally succeeded on the ground of the promise broken by his mother. In the nature of the promise, the order is made the son will be getting the house and the mother is allowed to continue stay in the granny flat.
The objective of the case of the Ashbury Railway Carriage and its item Corporate Limited against Ritchie is that for the Ashbury Railway Carriage and Iron Corporations Ltd was selling hiring of landing the wagons and the railway carriages. These activities were setting for rubbies, rolling the stock, and the machineries on the plants. The House of the Lords were considering that the contract is beyond the outside of the power of the company because it was not included in the clause and the objects of the memorandum. From another side, the transaction which entered by the company has breached the Constitution of Australia and it has not been in competence or related to the part. Therefore, the contract has the legal ethics in the transaction, which implies that Ritchie's claims that the statement for company and branches of the contract are equal. However, the contracts will be more considered at the first. Besides, any transactions that made will included in the clause of the optic test in the company will be held within the capacity that is valid. There is another point at which the memorandum of the case of the Ashbury that is regarding the contract and the object that are restriction of the powers of the company. Well, they do not understand the difference of the objects that are according among those parts within the Constitution. These descriptions that actively set for the company to carry on. The company and the third parties who involved are required to be able to carry the activities of the company. There is difficulty arising with the ultra-various rules, and those that are dealing with company will be checking that if there is within the capacity for entering the contract only by looking at the memorandum that the register of companies will otherwise at risk. It will be very easy to find themselves to be unable to enforcement of the contract based on the law.
Hello, my name is Shimeng Hou. My student number is AUN2118. Today I'm presenting business and corporation law about half of Irish Railway Carriage and Iron Code Ltd. We reach 1875. With my group number. The Ashbury Railway Carriage and Iceland Company Limited. In the memorandum of the clause 3 centers, the objects are for selling and making, heating, or landing, and railway carriages. The companies was agreed and the brother along which will help them to building railway in the beginning. Most of the time, that companies will have limited share that are in company based on Companies Act of 1985. Most of the time, the company was doing those tasks which are required to fulfill to propose that stated. My group member will have the second film in the series.
In conclusion, the moral of both of the case above is that the final decision made by the court must be upheld by the party involved in case and will be referred to be model and feature case as long as the common law decides. For common law decides as a reference to future judges, it is necessary that be objective of decision by the judges in previous case and understood by the future judges so that it can make a judgment based on the active reality as that the previous decision. As it can be seen in this company case and required to have a state considered that outline rules of the company responsibility. And lastly, Every nation has its own laws, and every family has its own rules. The property to remind everyone that you can break the rules, but you cannot come and offer around the rules that are set by a country.